Good afternoon, and thank you everyone for attending today's webinar, HIPAA and Other Privacy Issues for Medical Practices, presented by David Meinhardt of Hardwood Lloyd. Please be aware that there will be a question and answer portion today at the end of the webinar. To avoid frequent interruptions during the webinar, please type your questions in the question box located to the right of your screen. They will be answered in the order received during the question and answer portion. Additionally, an electronic version of this presentation will be emailed to all participants following completion of today's webinar, and a recorded version will be available on the website for members only. Again, NJMGMA would like to thank you for attending, and I'll now turn things over to David.
Thank you, Alex, and thank you everyone for logging into this webinar, Privacy for Healthcare Providers, HIPAA and more. And like anything else we do, I have some goals here, and I guess probably the number one goal I have is for those who are listening in and watching the slides that after the session you look to your practices and maybe you find some quick fixes and you realize there's things that you should have done but haven't, and take the next steps to move forward and make sure that you're maintaining the appropriate processes and security elements in place to protect the privacy of your patient's information. So here's the standard lawyer's disclaimer that this is presentation is for informational purposes, and if you do have a need for legal guidance on something, that you retain counsel to assist you in that regard. So as it's Alex is online, indicated, I'm an attorney with Hardwood Lloyd. I've got a number of years of experience in dealing with healthcare and data privacy law, as you can see from the gray in the picture, and I'll just leave it at that. So as I said, it's not just HIPAA, and I look at this as being a quick refresher, because you all know that there have been requirements related to HIPAA for about 15 years. It'll be 15 years in April, because it was April 2003 when the privacy laws became effective. And yes, time flies when you're having fun. And as I point out here, it's not just HIPAA, though I'm really going to be focusing mostly on HIPAA because that's the more substantive area that we have to deal with. But I do want to just mention some of the other areas that apply, and those are the New Jersey law related to security breach notices and protection of personal information, not just PHI, protected health information. Also, there's a law related to keeping social security numbers secure, and another driver of the need for keeping up to date on compliance with privacy issues is the evolution of technology. When HIPAA started, smartphones didn't exist. At least they didn't exist in the mass market. But that's one area where there's just a lot more access to information. You didn't have text messaging of any great degree. You didn't have the same kind of cyber threats that exist today, ransomware and things of that nature. So because of the fact that technology continues to evolve, there's a need for continuing to keep abreast of what you need to make sure that your information is being adequately protected. The Federal Trade Commission also could get into enforcement of privacy issues if they believe that your privacy notices constitute, if they are misrepresentations of what you're doing, they could be deemed unfair and deceptive practices. And at the bottom, you'll see I reference substance use treatment centers, and that relates to federally funded drug and alcohol abuse centers where they have to comply with section of the regulations known as 42 CFR Part 2, which is, something that I think if you're in that business right now, you should be aware of it, but I'm just going to touch on it a little later. In particular, if you're not in it now, but you're thinking of having the practice evolve to go into that area. I'm going to try and repeat one thing a number of times because I just, from the readings out there, I can see that, staff awareness of HIPAA compliance and privacy in general is really an important factor in reducing, breaches and improper disclosures of PHI. And, you can read things out there about, some of the, outrageous things people have done. I've done a little research in that regard for, what some people actually do. And I came across one, and I'll have to admit I didn't actually confirm it, but it indicated that there's a medical center employee posted a photo of a patient's medical record, the name included on the person on her own Facebook page, and made some comment about the patient coming in secure VD and getting birth control instead. And the person who posted it on her Facebook page said, this isn't a violation of HIPAA. It's not a privacy violation. It's just Facebook. It's not reality. If that really happens, you don't want that to be one of your employees doing it. So when HIPAA started, there were things you should have done. And if you didn't do it, here's an overall listing of what you should do. So you certainly created notices of privacy practices, and you made the staff aware of certain HIPAA requirements, such as getting a valid HIPAA authorization to release results. You should have also done a risk analysis. That's a requirement under the HIPAA security rule. And HIPAA has actually two rules. There's the privacy rule, which became effective in 2003, and the security rule in 2005. So here's just a listing of just some basic things, workforce training, implementing the appropriate security, business associate agreements. Business associates are, important part of anybody's practice. I mean, you don't do everything yourself. You have third parties that assist you, and those vendors, those contractors, many of them are getting access to PHI. If you have a breach, you want to understand that you have breach notification obligations. To the extent that you have not done a risk analysis, there are tools out there, and I can send you links, after the session of some things that I think are valuable. Certainly the Office for Civil Rights, which enforces HIPAA, they have some good material. Also the IT, elements of the government has that. But, overall, you should have done an inventory of where you have PHI, particularly electronic PHI, and evaluate the threats that there are to the HIPAA, the protected health information. The first one here is kind of important. Avoid the appearance you don't take privacy seriously. I guess you can think of it as good customer service. One reason that someone might get investigated for HIPAA violations is because a patient files a complaint that they didn't, that your practice was not appropriate. So some basic things like making sure your staff isn't loudly discussing PHI in public. You'll see the bottom one I have there about patient sign-in sheets, and I know you see it all the time. I have for some reason, it's just something that annoys me, is where it has a place to put your first and last name. I you shouldn't really have patient last names just sitting out there in public, and different places handle that in a different way. But essentially, you really don't want to, you want to minimize the opportunity for someone to complain and have an investigation started, because if they come in and investigate, if anyone who's in a regulated industry, whether it's you're dealing with the EPA or OSHA or the OCR, if someone comes in, because there's just a lot of stuff to be on top of, they're often going to find something, even if you're doing a good job in general. So, have the administrative, physical, technical pieces of your security in place. And whatever you're doing with regard to your HIPAA compliance program, it's important to document it. Like you hear in many cases, if it hasn't been documented, it hasn't happened, at least from a regulatory standpoint. And you want to show that you have trained your employees, that you've done a risk analysis, again, that you take your HIPAA compliance obligations seriously. Then, of course, there's also the concern of going into overkill. And I had a personal personal situation it was a month ago, I guess. It was actually my wife's issue. She was helping out her 91 and 89-year-old aunt and uncle with some health issues. They're out in Long Island, and she needed to get access to their PHI. And this medical practice, which I think is part of one of the largest groups in New York, indicated that her aunt and uncle need to come into the office to bring in the HIPAA authorization. They wouldn't accept it being brought in by someone else. That's just someone looking for a complaint, to the OCR. And if the OCR is looking at you, again, they might find things that, you weren't doing properly, though most of what you were doing was proper. So just some listing of things here, backing up your electronic systems. One of the requirements is that, you make sure that the PHI is available when you need it. So if there is some kind of a system failure, you're able to get it quickly through a backup. And also to reduce ransomware risks. I mean, I don't think ransomware, where a malicious actor, locks up your computer and is seeking money from you, or actually bitcoins from you, to unleash it again. That didn't exist, way back in 2003. Encrypting any mobile media which may contain PHI, that's laptops, portable hard drives, the USB drives. I mean, it's not unusual to read about, losses, HIPAA issues, because a laptop was stolen. So, be wary of that. Business associate agreements, I'm going to go into more detail on the next couple slides. Appropriately disciplining HIPAA violators. That's just like any other type of discipline for someone who doesn't follow the rules in your practice. Again, you want to document that too. Lastly, I'm just going to, on this slide, reference the 42 CFR Part 2 issues. So if you're a federally assisted entity that provides those kinds of services, and that's typically organizations that are federally assisted and hold themselves out as providing alcohol or drug abuse diagnosis, treatment, and referrals. And the main distinction between HIPAA and 42 CFR Part 2, which actually 42 CFR Part 2 dates back to the 70s and was, so predates HIPAA by many years, a couple of decades. The main difference between the two, that at least in today's world, requirements, is that under 42 CFR Part 2, if you have patient records that are covered by those requirements, if someone wants to send those records to a third party, typically today you use you get someone to fill out a valid HIPAA authorization, and they send it out, you'll send it out to the third party. It can just name the entity that it's going to. It could be a law firm, it could be an insurance company or whomever. However, under the 42 CFR Part 2 regulations, you actually need to name the person who's receiving the medical information. While they did recently make some changes to the regulations for the first time in 40 years, and that was really to allow for health information exchanges to get access without having to name an individual. It's still an area that if you're dealing with those regulations, it's a bit of a challenge, in particular for these qualified service organizations, which are essentially the business associate equivalent who deal with with these federally regulated entities. Probably not an issue if you're doing it, if you're engaged in that type of practice now, since you should have been aware of it. But if you're planning on going in that direction, it's just something worth being aware of. So going into business associate agreements, and hopefully this is stuff that you all know about, but in case you haven't been keeping abreast of things. So business associates are those third parties who provide services or goods to you and have access to PHI of your patients. Some examples of a business associate is, our billing and coding services, answering services, transcriptionists, document storage companies, claims processors, health information exchanges, and collection agencies. That's just a number of them. So you should be looking at the third parties who provide services and goods to you. So if you've got 20 of them, then you take a look, okay, these 12 are actually getting PHI from us or on, behalf of us. So for those that apply, you should be sure that you have a business associate agreement in place. And in 2013, the regulations were updated. Really, it was associated with the Affordable Care Act. And, the most significant change with regard to business associates is their obligations got ramped up to be essentially the same as a covered entity. And they also have the security breach notification requirements. So any old business associate agreements that weren't updated in that time frame should be updated. In addition, you should really be taking reasonable steps to vet their capabilities to meet their business associate obligations. And, there have been penalties, assessed because of the failure to have a business associate agreement in place. One interesting one from 2017 was a small healthcare provider in Illinois, Center for Children's Digestive Health, had to pay $31,000 to settle claims of HIPAA privacy violations because they had been using a business associate, a company called FileFax, which stored records for them, and they didn't have a business associate agreement in place. Now, it turns out that the Office for Civil Rights was investigating FileFax because of a breach they had. They had left hard copy PHI available. So in investigating FileFax, they identified some of their clients. And I'm not sure why, maybe this was the only client that they had that, sent them PHI. So this Center for Children's Digestive Health, got drawn in because they didn't have a business associate agreement in place. So, just something to be aware of who you're dealing with. Getting into HIPAA enforcement, they do it based on different criteria. Sometimes the student investigation of patient complaints, Other times it's in response to a breach notification you send out. And there are also routine compliance audits they perform. So they really don't perform that many. And when they do the audits, at least up to now, they're really more educational in nature rather than, seeking to, hit on someone with an enforcement, penalty. And the penalties are infrequent, but, they can arise. And, people should understand that when they're disclosing PHI, that if they're violating the rule, it can come down to issues that can also hit you from the state level. A state attorney general can also enforce HIPAA. An important element is also cooperating with complaint investigations, because failure to cooperate raises the stakes. And they often find when they're doing an investigation that a risk analysis wasn't done, and it's something that needs to be done. Looking to the issue of audits, frankly, most of them are desk audits where they'll send you an email and asking you to answer some questions and provide some information. They've done a small number of on-site audits where they come to your site. But really, I believe there's only a couple hundred audits that have been done in each of the past couple of years. I don't know whether that's going to be ramping up. And just with regard to enforcement, it has ramped up in the last couple of years. Information I've seen indicates that the OCR has received over 170,000 HIPAA complaints since 2003. They've only imposed civil money penalties in about 53 cases for a number of millions of dollars. So the big hits tend to be large providers with significant, PHI that's been exposed, or an overall, poor HIPAA compliance program. So discussing just, some of the violations where corrective actions have been issued, it's things like, people in waiting rooms, speaking loudly about PHI, having computer screens, viewable by patients. It's faxing to the wrong number and without a confidential cover sheet. It can be social media and websites where there are photos, where there's text disclosing PHI, whether on the practice's site or a staff member's site. And then that goes again to the issue of awareness. Also, staff, and I don't know how commonplace it is that people would know this, that, just because you're a staff member at a medical practice doesn't mean you can look at everybody's PHI. They should only have access to individuals who they are involved with the treatment or the billing or, one of the operations where they need access to PHI. So your staff members should know that, they can look at PHI to the extent it's for patients that they have some relation to in the treatment or otherwise, other operations of the practice. But they can't just go look up friends' information or relatives, and depending on what kind of how your practice looks at things, even if a friend or a relative asks them to look up some information, like get their lab results for them, that's really, if it's not someone that they're involved with, it's really best to, make sure that they're not engaging in those type of practices. Obviously, there's the one about telephone messages, where PHI is left on the machine. You really don't know who else has access to that message. And another common one is with regard to hard copy, just not shredding PHI when disposing it. Another area that doesn't probably get the amount of attention it should, relates to copiers. There was an HHS settlement with a large health plan because, they returned multiple photocopiers to a leasing company without erasing the data contained on the hard drives. And when I say erasing the data, it's not just, sending it to the recycle bin, and I don't know how it works on a copier, but it's got to be, an erasure that, totally wipes it out so it can't be retrieved. And then just talking about, large HIPAA fines, again, not something that's typically going to arise in a small practice, but just last month, Fresenius Medical Center, which provides dialysis services, they just paid $3.5 million, and it was mostly due to unencrypted computer equipment being stolen. Apparently they had 5 breaches. Getting into privacy breaches, a breach is an impermissible use or disclosure that compromises the security or privacy of PHI. So those types of disclosures or uses are presumed to be a breach unless you can demonstrate there's a low probability that the PHI has been compromised after performing a risk assessment. And I know I had, in the past been involved in situations where you want to be able to look at that specific situation, do a risk assessment, and determine, there really is a low probability. But again, if you're doing something of that nature, you really need to document how you came to that conclusion in case there is any kind of a look-see at you from the OCR. There are also exceptions to the definition of a breach. It's listed here, they're listed here, but if there's a breach, you need to follow the prescribed process. You need to notify the patients as well as the Office for Civil Rights. It's similar to the process related to state breach notification laws, which I'll get into in a little bit, but I think it's best to engage legal counsel if you believe a breach occurred. Want to understand your rights. So I've mentioned awareness training a number of times, probably not as much as I intended to, but this pie chart of data breach trends, helps to point out why I've wanted to make that point. So Beasley is a company that provides professional liability insurance for technology, and they issued this report late last year discussing healthcare data breaches for the first 3 quarters of 2017. And if you look on the right side of the screen, you see unintended disclosures, 41%. So what do they mean by an unintended disclosure? They essentially mean human errors. So they are the biggest factor in HIPAA breaches. As they indicate in their article related to this, they say whether it's an email containing PHI sent to the wrong recipient, discharge instructions given to the wrong patient, or a server containing PHI accidentally left open to the public. Healthcare entities continue to struggle with human error on a regular basis. And again, with regard to the issue of PHI out in the public, there was one situation where there was a calendar. The calendar for a facility was actually accessible on the internet. There was a $100,000 settlement after a physician practice had posted patients' information on this publicly accessible internet-based calendar. And in this situation, the investigation found that the practice failed to document staff training on security policies and procedures, conduct a risk analysis, and obtain appropriate business associate agreements. Looking to this pie chart, So unintended disclosures is, twice what any other clause is. And so you have 19% are related to hacks or malware. So that's outside malicious actors. The 15% that are insiders are individuals that work at the site and are intentionally looking at PHI that they should not be looking at. It goes on further down the line there of different losses. The last one on social engineering is where a hacker deceives employees to disclose information, whether it's disclosing passwords or things of that sort. Again, it goes back to the importance of making HIPAA compliance part of your culture. Try to move along here. Texting PHI. PHI shouldn't be texted unless you're using a secure texting platform, because the standard texting service that comes with your phones is not secure, so your texts, could be accessed by third parties. The second bullet there on patient orders to a hospital is really not a HIPAA issue, but I thought I would just, put it in here because it's a recent CMS memo that brought this up, that regardless of whether it's secure testing or texting or just unsecured texting, you can't text patient orders to a hospital, not based on HIPAA, but on the Medicare conditions of participation or coverage. And I'll have to say I'm not really familiar with the Medicare conditions of participation or coverage, but I think it's really got a lot more to do with quality issues rather than, it's not a privacy issue in that regard. Emailing PHI to patients. While the security rule of HIPAA indicates that ePHI, electronic PHI, needs to be encrypted whenever it's deemed appropriate, that's something you make a case-by-case determination of. And I believe, I'm not certain of this, but I believe most organizations, don't encrypt their, in-house systems, their desktops and things of that sort, though it would be a good practice. So emails need to be encrypted, but as you'll see, in some cases, there might be a patient who's insistent on, sending and receiving PHI via unencrypted email. And actually, the reason I even brought this one up is because a physician told me he had a patient who insisted on sending him medical records from a prior provider through regular email. And, he didn't really want to accept it that way. And I did a little research into it, and I did see that the commentary in the rules, point out that a healthcare provider may agree to, deal with PHI with patients in unencrypted email, but the important thing there is warning the patient of the risk of a third party accessing the PHI, clearly document the warning, have evidence the document was signed. So it's not a great thing to do, but there may be some circumstances where you want to consider that. The judgment call. So the Office for Civil Rights, their website really has a lot of good information. They have free training materials. I have some links posted here, including some I thought were interesting. These interactive training models where they'll show you a fact pattern and they'll ask some questions, and it indicates you can get free CME out of it. So, something worth considering. And if you do, take up using this, these resources, make sure you document it. So again, you can show good faith in the culture of maintaining HIPAA compliance at your organization. I also mentioned the Federal Trade Commission. Here's just their, I just copied this down from their FTC guidance on privacy for business. Take stock, scale down, lock it, pitch it, plan ahead. You can look at their information at your leisure. So New Jersey has an Identity Theft Prevention Act. It's like, I guess, I'm trying to think whether it's 49, I think it's 49 states have their own version of this type of a law. And that's the law that we've all dealt with as a consumer, where Target or Equifax's systems have been breached. You get the letter, they offer you monitoring, credit monitoring. So I'm not going to go into the details here. You know, it lists, you know, defines what a breach is. You have to send out notices, personal information. Again, when you're dealing with this law, is obviously broader than PHI. So, you know, if you find yourself having to deal with a breach, you're going to want to engage the necessary team, including legal counsel, and it may be, you know, IT, depending on the nature of the breach. To the extent that you've got patients who are from another state, the law in certainly the law in New York and Pennsylvania and Connecticut and Delaware are not the same as the New Jersey law. So you would actually need to look at those laws too. Looking to Social Security numbers, I think we all know that keeping Social Security numbers confidential is something we want to do. I always recommend that people don't request Social Security numbers, since, you know, they're just a risk waiting to happen. And I understand that still is an issue for Medicare beneficiaries, because the Social Security number is the bulk of what their ID number is. Though I guess that starts to go away. I think starting in April, they're going to be changing the ID numbers over to something that's more secure. It's safer. It's a long time coming. Getting back to the culture of privacy, you do want to create an environment where the importance is part of your practice's culture. Obviously, think about your own PHI and that of your family, you know, and workers. You know, you wouldn't want it out there. So, I mean, here's just an example from, and I'm not recommending them, but I, you know, came across this from a security awareness company, something that you could post. And I didn't know that cyber criminals would rather have our PHI than our credit card numbers. So I have read that health information is considered extremely valuable, because there's so much information there, including the Social Security number in many cases. So in conclusion, things that I'd like to, you know, make sure that you're thinking about is not looking willfully negligent regarding HIPAA compliance, educating your staff appropriately. I think from what many say, pictures help, as in that last one that I just showed you. Take it seriously, and if you haven't been on track, hopefully this, you know, session, you know, will help get you back on track. So this was a quick overview. I can provide you with some links to information that I think might be helpful if you email me, and that ends the formal presentation.
Okay, so we have a question. When hiring a locum through an agency, should we have a business agreement with the agency? Is a signed confidentiality agreement enough, or should we also have a signed business agreement with them?
So just so I understand the question, you're bringing in a doctor through a third-party agency, right? And the doctor is going to be working on your site and accessing PHI, but the agency will not be getting access to any PHI. I'm assuming that's the fact pattern that we're dealing with here. And again, if they're not accessing, if the agency is not accessing PHI, I don't see them as, you know, needing a business associate agreement. It really all depends on what kind of information they're accessing. like anything else we deal with, the facts matter. So if that's the case, there shouldn't be a need for a business associate agreement with that agency. However, and with regard to the doctor who's working in your practice, they would be covered by your workforce policies, and they should be made aware of what your HIPAA policies are. Hopefully that answers the question.
That was the only question we have. If anybody has any questions, please type them in the question box now. We'll just wait a minute, see if any questions come in. Okay, so if nobody has any questions, we'll end the webinar for today, and it will be available on the members only section of the website, and you will get a copy of the presentation in your email. Thank you, everyone. Thank you, David.
Right. Thank you, Dawn.